Well, thank you all very much for taking the time to be here. For those on the commission, thank you for really an extraordinary amount of work, and not just a lot of work, but an extremely high-quality product on a very difficult topic. So we thank you very much. Maybe for those people who don't know who's in the room, maybe we'll just go around the table. Chief, if you could start, please.
Certainly. Steve Krokoff, Chief of the City of Albany.
Good afternoon, Melanie Hartzog, Executive Director, Children's Defense Fund, New York.
Good afternoon, Anthony Pacenti, Oneida County Executive.
Good afternoon, I'm Sophia Elijah. I'm the Executive Director of the Correctional Association of New York and co-chair.
And I'm Jeremy Creelan, also co-chair.
I'm Jackie Green, Executive Director of the Commission.
Good afternoon, Madison County Sheriff Alan Riley.
Good afternoon, Joe Mancini, Probation Director, Schenectady County.
Emily Tao Jackson, Executive Director of the Tao Foundation.
Great, thank you very much. We're going to ask the Commission to go through the report. Before we did that, let me give you a little context. This is a slightly different situation than we've had in the past when it comes to the State of the State address. State of the State is this coming Wednesday. It was postponed because we had some personal issues early on. But the State of the State is basically an announcement of the policy themes that we're going to pursue for that year. And normally in one address, although it's somewhat lengthy and somewhat boring, don't tell anyone I said that, it goes through the full litany of all the policy proposals that we want to pursue. They then become pieces of legislation, and the legislature decides what to do with it. But normally the State of the State contains all the policy proposals. We had an abundance of policy proposals this year, which I guess is a good thing. And they were not simple policy proposals. They dealt with many complex problems that we've been trying to solve for a very long time. And the complex problems don't resolve themselves to 30-second explanations or 30-second solutions. It takes time to understand what they are and really work your way through them. It's one of the reasons why they're complex problems. It's one of the reasons why they persist so long. Government doesn't have a long attention span. If you can't describe the problem in 30 seconds, and if you can't describe the solution in 20 seconds, it's probably not going to happen, right? You have to get everything down to a bumper sticker. This is one of those issues that has gone on for a long, long time without resolution. And an issue, frankly, where we have done a lot of damage in the meantime. Your imagination can paint vivid pictures when you talk about exposing a young person to a state prison. For those of us who have spent time in state prisons, I can tell you the reality is worse. And I've spent time in a state prison in an official capacity, I can assure you. But the reality is actually worse than what you would think. So we announced that we were going to put together a commission of the top experts, let them really take the time and work through the issue, and have the issue ready in time for this legislative agenda, which is precisely what they have done. And precisely what we're going to go through now. It will then be included in the State of the State address, but in the 30-second capsulized version, because that's all the time we'll allow. We've done that with several other issues. We have some economic proposals that we've already discussed and laid out in detail, housing programs that we're going to pursue, a really robust housing agenda, a robust minimum wage agenda. So live and learn. This is my 5th State of the State. Hopefully they get a little better each time, right? Otherwise I'm not doing my job. But certainly this is the most complex, policy-heavy State of the State and policy-heavy agenda that we've ever put forth. The challenge is now going to be to get the legislature to actually pay attention and work through the policy. But this is Albany, this is government, so one challenge at a time, stone to stone across the morass, as someone used to say. With that, let me turn it over to Mr. Jeremy Creelan, who will start off the presentation.
Okay. Thank you, Governor. I'm actually going to turn it over to my co-chair, Sophia Elijah, briefly, and then I'll go through the presentation. Sophia?
Okay, thank you. Well, today we celebrate the life and legacy of the Reverend Dr. Martin Luther King, a leader, not a dreamer. Dr. King was a leader who taught us that we are all part of one human family, all races, all ages, all ethnicities, and all members of the LGBTQ family. We must all care about every member of the human family as ours. That truth exemplifies the work of the Commission as we focused our attention on achieving better outcomes for the young members of our human family and ultimately safer communities for all of us. Though we Commission members all come from different walks of life and have different perspectives, together we grappled with these complex issues and crafted a set of comprehensive recommendations that we unanimously endorse. That is no small feat, and we are tremendously proud of the recommendations we are making to once again make our state a national leader. We take it as a tremendous sign that you have chosen this day to receive and consider the critically important recommendations for reform that we are here to present to you as a Commission. On behalf of all of us, thank you for the opportunity to serve the people of New York. With that, I'll turn it over to Jeremy, and he'll start us off.
Governor, on behalf of the members of the Commission and myself, I want to thank you for the opportunity to be here and thank you for the opportunity to serve on the Commission and to develop this report on this critical issue. Before we jump into our findings and recommendations, I just want to add a word of context here. Now, as in so many areas, New York was actually once the unquestioned leader in juvenile justice policy. And ironically, New York State was actually really the first state to choose to place juveniles convicted of a crime in separate facilities from adults. This is the House of Refuge in New York City on Randall's Island, started in 1824, and in 1846, the legislature actually put into law that the House of Refuge would be the place, the exclusive place where juveniles would be housed after being convicted of a crime. Now, in many ways, as a result, the effort that we're focused on today and in this session is making New York State the undisputed leader in this area once again. And that process of reform in this area has already, of course, started thanks to your leadership. In 2012, you achieved passage of the Close to Home initiative. Instead of warehousing juvenile delinquents from New York City hundreds of miles away, and thereby making it much harder for them to repair and strengthen their social and family connections to their community, New York City youth are now being placed in or around their communities and getting the programming and the support that they and their families need. You also achieved major changes to the law to require detention decisions, whether a youth is detained, to be based on an objective risk assessment tool rather than just someone from probation looking at the files and reviewing the files. That reduces implicit racial bias, it avoids unnecessary detention, and it promises to save precious resources formerly spent on detention. And in 2011, you established for the first time a permanent funding stream for community-based interventions to help youth and families as an alternative to pretrial detention. Counties are now reimbursed at a higher rate for such interventions than they are for detention, which is good for youth and communities, good for counties, and good for the taxpayer. And last but far from least, you created the Justice Center to stop abuse inside facilities, and the Justice Center is already making a major difference curbing such injustices. So you've already established a tremendous legacy of reform in this area. Of course, there is still work to be done, and despite New York's early leadership, by the middle of the 20th century, New York had already started to lag in some key respects. By 1927, most other states had raised the age of criminal responsibility, 28 states to age 18 and many of the others to 17. New York was still at 16. And New York is now one of only 2 states that treat 16 and 17-year-olds as adults for all purposes in the criminal justice system. That was the reason why you appointed our commission, and that was our starting point. Now, over the past several months since April, and thanks in large part to the support of the Vera Institute for Justice and the foundations that generously supported the effort, the commission's work has been about as deep and as extensive as any commission I have seen. And in the space of less than 7 months, a remarkable amount of work has been done. There were 14 focus groups with over 200 participants all across the state, over 40 interviews with stakeholders and national experts, intensive data analysis, weekly meetings about the current system, public hearings with over 20 witnesses. We consulted in person with leaders from other states, Illinois and Connecticut in particular, that have gone through this process. We visited jails, detention centers, juvenile facilities, Rikers, residential treatment facilities. And as a result, we've come up with a series of findings, which I'm going to allow my co-chair, Sophia Elijah, to go through. Sophia?
Thank you. Well, what areas did we find were in need of reform? First, and perhaps the most well-known, is the impact of detaining 16 and 17-year-olds in adult jails and prisons before trial and imprisoning them in adult prisons after sentencing. Nationally and here in New York State, the research has shown 2 key facts. First, youth of that age often suffer horribly inside adult facilities. They're far more often than adults to suffer from sexual and physical abuse, mental health deterioration, tragic outcomes, and often they fare and suffer from low-level crimes. And second, and I would suggest that anybody here who has raised a teenager will not debate this, we know that their brains develop slower. Well, it's not slower, but the impulse part of their brains develops last, and that is the cause of their behavior. Any parents disagree with that? No. Okay. So what is less well known is that this brain development also impacts what happens with respect to their criminal-involved behavior. Go to the next slide. So our research also made clear that what should be obvious is that whatever impacts the current system has on any youth, on any community, these impacts are borne disproportionately by people of color. It is also important that we don't ignore that particularly in upstate rural areas, white youth are deeply affected by this system as well. But if there's injustice in our juvenile justice system, that injustice has a disproportionate impact on communities of color that need to be acknowledged and is an extra reason to get these reforms passed. We also found that New York State lags severely in giving young people a second chance by allowing certain crimes committed as a teenager to be sealed or expunged later if the person stays out of trouble. Now, our current law does allow courts to give young offenders youthful offender adjudication instead of a criminal conviction for those 17 and under. There are limitations, however, to the youthful offender law, which I will discuss, but it does ensure that 75% of 16 and 17-year-olds convicted in criminal court have only a confidential record. However, there's still about 1,600 minors a year who obtain criminal records and who, unlike most states, New York has no mechanism by which to have their criminal records sealed or expunged, even if they've committed them when they were young. And second, the crime was not serious. And third, they have lived a life free of any crime after that first encounter. Criminal records present long, lifetime barriers to education, access to employment, housing, and various other benefits. So when we talk about giving young people a second chance, this is a major deficiency in our existing state law. In order for a probation department to divert a case so it doesn't turn into a court case, or for a judge to consider alternatives to sentencing a youth to an out-of-home placement, the county has to have solid options for services for youth and their families. We now know what works, and intensive family therapy and mentoring is important. We conducted a survey, the first of its kind in our country, and we looked at all probation departments across the state to learn what services they had to offer as an alternative to a court-imposed sentence or detention. And here's what we found. Only 5 counties have 0 evidence-based services for youth. Excuse me, a total of 5 counties have 0 evidence-based services for youth. 24 counties have only 1 or 2 evidence-based services for young people. And only 5 counties have more than 5 evidence-based services for young people. So we're lagging behind in what services are available in the various counties by probation departments. The key is that those services are far cheaper and more effective in reducing recidivism and allowing the case to wind its way through the court and have youth detained and ultimately placed. Yet New York State does not have the services we need in many counties. This has a ripple effect and results in more detention, more cases, more prison, more cost, and ultimately more crime. We also found, even though the number of young people detained or incarcerated has declined significantly as a result of the reforms that you have already implemented, more can be done to get very low-level offenders into alternatives to detention or incarceration that works well. About 1,700 16 and 17-year-olds annually receive sentences with some jail time for misdemeanors that do not involve violence. More than 250 young people under 16 were sent to placement last year for misdemeanor offenses. Those are the youth who are actually accused of a crime. In addition, there are juveniles under 16 who are placed out of their homes for what are known as status offenses because they are incorrigible or their parents simply cannot get them to attend school. Those are persons in need of supervision, or what we call PINS children. New York State spends over $100 million every year to place those children, often in places that are not much better than juvenile detention centers. Meanwhile, other states have shifted their focus and their resources from such out-of-home placements to intervention services for families and young people that have much better success rates. Those services have reduced recidivism, more costs, and have cut costs and reduced the placements of our young people, thereby resulting in better crime rates. We also found something that may surprise you and that is critically important. Our current system may be actually undermining public safety unnecessarily. Research has shown that youth processed as adults have a 25% higher likelihood of reoffending and reincarceration than young people processed as adults. In other words, treating kids like kids in our system has been shown to reduce crime. These reforms will make us all safer. Jeremy?
Thank you, Sophia. So I'm going to talk a little bit about the recommendations. Those are some of the key problems we identified, and they all at their core stem from the raise the age issue itself. So first and foremost, the Commission recommends changing the law to raise the age of criminal responsibility to 18. And we talked to Connecticut and Illinois, and they all said the same thing. Phase this change in so that you can build the system and services you need to make this reform a success. And in Connecticut and Illinois, it was very interesting. They both expected a massive influx of 16 and 17-year-olds into their juvenile system as a result of the change. They expected to have to build large numbers of juvenile facilities and new courts, but in the end, the influx didn't come, and that's because of the planning and the services they put in place to provide alternatives to detention and to provide alternatives to the court cases themselves. So we recommend a phase-in. January 1st, 2017, the age of criminal responsibility would be raised to 17, and January 1st, 2018, the age of criminal responsibility would be raised to 18. Second, the Commission recommends that no person under 18 should be detained or imprisoned in an adult jail or prison. And the report details how to get this done. In particular, the Commission concluded that this is a tremendous opportunity for New York State to lead the nation in developing new secure juvenile facilities around the state that use the best practices for rehabilitation and education for these youth. Missouri is the gold standard here, and there are many elements that are already being incorporated into OCFS facilities. We believe and recommend that a network of small facilities under 25 beds should be created for the additional secure capacity that's needed, with intensive programming and support, staff teams that are focused on getting the youth the help they need for a successful reentry, less bureaucracy, and more direct staff counselors. These facilities are not only cheaper, but they're also much better at reducing recidivism. In addition, we recommend a statute, let me go back. We recommend a statute that prohibits detention and placement for low-risk youth charged with nonviolent misdemeanors, except where specific imminent threat to public safety is found. Other states have done it, and New York should do it too. In addition, the Commission recommends removing a whole series of barriers that are identified in the report to successful diversion or adjustment of appropriate cases so that they don't end up in court at all. I won't detail those reforms here, but one of the most critical is investing upfront in the intensive services that allow probation and courts to divert cases early and without detention. That saves a lot of money in the out years and reduces recidivism. Now, probably the most difficult issue, the most contentious issue that we wrestled to the ground was the issue of how to handle the 16 and 17-year-olds in court once the change is made. We start with two premises or two findings. One is that in courts as well as in prisons or jails, it's far better for public safety and for youth to treat young people differently than adults. But it's also important to recognize that every single state, all 50 states, have carve-outs so that the most serious violent offenses committed by youth are handled in the first instance in adult criminal courts. So the Commission developed a very balanced approach that ensures that every single person under 18 would be handled differently than they are now and more appropriately. First, all misdemeanors and nonviolent felonies for 16 and 17-year-olds would be handled in family court, where juvenile delinquency cases are handled now. That means that 9 out of 10 cases against 16 and 17-year-olds would go to family court. Second, serious crimes of violence, violent felony offenses, and certain other major offenses committed by 16 and 17-year-olds would originate in criminal court, adult criminal court, but not in the current courts. We recommend the creation of new youth parts in the criminal court system with specially trained judges who are expert in the ways and needs of young people and their families. This is a proven concept elsewhere and also in New York State and New York City, as we know. In addition, appropriate cases could be removed, as they are now, to family court. And the judges, one of the things we recommend is that the judges in those youth parts be clothed by statute with concurrent Family Court Act and criminal court jurisdiction, so that for appropriate cases, they could, when they decide to remove, if they decide to remove a case to family court, they could do it in one of two ways. They could either transfer it physically to the family court, so the family court judge handles it, or they can keep the case in the appropriate case in their courtroom, but apply to that defendant the Family Court Act, so they could handle the case in the same manner as the family court. For violent felony offenses and for certain robbery 2 charges, there would be a new rebuttable presumption in favor of removal to family court. And the DAs who would retain control of those cases regardless of the court could rebut that presumption for removal if the defendant played a primary role in the crime or other aggravating circumstances are present. And this is the best, basically, of both worlds, the benefits of family court, but also in the appropriate cases, the flexibility for judges and DAs to keep defendants together in one courtroom rather than splitting cases apart in every situation where removal is appropriate. And even those cases, important to emphasize under our recommendations, even those cases that remain in criminal court and are not removed would receive juvenile probation interventions and would never be detained or incarcerated in adult facilities. We also recommend a series of reforms to give youth a true second chance. First, we recommend expanding eligibility for the youthful offender status or youthful offender adjudication, which Sophia mentioned earlier, from 18 to 20, so that 18 and 19-year-olds would also be eligible for that, to have their records made confidential. Second, we recommend allowing those who committed nonviolent offenses at age 18 to 21 to get their records conditionally sealed for civil purposes if they remain conviction-free for at least 5 years after release from prison for felonies or 2 years for misdemeanor. And then on the other side of the equation, we heard from many people in law enforcement that they have significant trouble identifying that very small number of the most persistent violent offenders. And to address that and improve public safety, we recommend that if someone receives a youthful offender adjudication for a violent felony and then later commits another violent felony offense, then law enforcement and the court would be able to use that earlier YO adjudication as a predicate offense for charging and sentencing purposes. Together, these balanced reforms will place New York at the forefront of the pack in reducing the collateral consequences to young people who receive a criminal record, while also protecting public safety. To make this entire set of reforms work, and there are others that we didn't detail here, but it's a 200-page report, so they're in there if you get a chance to read it. To make this entire set of reforms work, other states have shown that we must invest upfront in the kind of intensive interventions that have been proven to reduce recidivism and reduce the need for detention and incarceration. We recommend establishing family support centers, which have been used in Connecticut, as part of their Raise the Age effort to provide those services. And as Sophia mentioned, we conducted a survey to identify the services that really are needed. Now, if all of these reforms in this report were passed and implemented, what can we expect to happen? First and foremost, we expect public safety to improve significantly. The proposals, when we modeled them, are projected to reduce personal crimes, crimes against people, between 1,500 and 2,400 over a 5-year period. And in Connecticut and Illinois, this is totally fascinating and as far as I can tell, unprecedented in policy areas. In Connecticut and Illinois, when they did this, both arrests and recidivism declined dramatically after the Raise the Age among 16 and 17-year-olds. So they expected this enormous influx of 16 and 17-year-olds, and in fact, not only did they not get that, but crime actually went down among that group, arrests and recidivism. So if all of these reforms become a reality, thanks to your leadership, youth will be treated as the young people they are at every step in the process. Young offenders who stay out of trouble will get a second chance so they can get jobs, enter the Army or college or law school, and New York State will once again be the nation's true leader in juvenile justice. Thank you very much.
Here, well done. Really well done. Great work product. I'm going to ask the panel, the rest of the commission, if they have any other comments. A couple of comments myself first, because this is very provocative. I started my career in the Manhattan DA's office, and I quickly got the sense in the Manhattan DA's office that it was too late. In the Manhattan DA's office, you see the same case over and over and over and over again. It's a 17-year-old, an 18-year-old who's in trouble. It's the second or third time they've been in trouble. They've gone through the juvenile programs, and now they're headed for state prison. And I was convinced at that time that we have to get there earlier. This is Martin Luther King weekend, Martin Luther King Day. One time in my life, when I was HUD secretary, Coretta Scott King calls and asks me to do the Martin Luther King address at Martin Luther King's church, the Ebenezer Baptist Church, which was obviously a great honor and also scared me to death. So I spent weeks researching Dr. King and to prepare for this speech. And one point that stuck with me from Dr. King, we tend to think of the nonviolent resistance, the passive resistance. His whole theory was a very activist intervention. And he spoke at length about how if you don't provide the early services, the early education, et cetera, then it's going to be too late when a person gets to the later teens. And in many ways, that is what is happening. When you hear the rest of the state, the thing I feel best about it is front-loaded, if you will, on this situation. Finding jobs, these were the highest unemployment rate, young African Americans, young Latino men. Finding jobs, job placement, job subsidies, making the education system work finally. You look at the census tracts where a lot of people who go into the criminal justice system are coming from. They're the same census tracts that have the failing public schools and have had failing public schools for a long time. Our failing public schools in this state, about 250,000 children have gone through what we call failing public schools. Can you imagine that? While we sit in this building, talk about it, 250,000 children go through failing public schools. So in many ways, we want to get there before this even happens, right? We understand that. One of the proudest legacies I can leave when I'm finished with this job, which I'm aiming for. Sometimes it's not what you do, it's what you don't do. I want to say that I closed more prison cells than any governor in the history of the state of New York. And I believe we're going to get there. So the early intervention, I understand. Question then is, unfortunately, if you do get to this point, what do you do? And this system sounds like it makes a lot of sense to me. Two questions I have just in terms of implementation and going to the practical. This approach sounds like it creates a different type of facility. We have Commissioner Annucci here and Deputy Secretary Terry O'Leary. This, as I take it, is a different type of juvenile facility than we now have. This is a violent juvenile in a small residential facility.
I can address that now. So some of the capacity, some of these 16, 17-year-olds, will presumably go to existing capacity at OCFS and the existing facilities. But to the extent there is a need for additional secure juvenile capacity, there may be a need we expect and model there to be a need to develop new capacity. And we think it's an opportunity for New York State to really lead in that area. When you have a blank slate and you're doing it anew, it should really meet best practices. And one of the things that's interesting in the research we found is that if it's 25 beds or smaller, it actually qualifies for Medicaid funding as well. So you get potentially much more federal funding for some of the intensive services that are provided at the facility. And the recidivism numbers at some of these the smaller facilities that they have in Missouri are much better than a much larger facility. So it's basically a recommendation to take that as an opportunity and not just expand capacity, but do it in a way that really helps reduce recidivism.
The state that had the best model facility would be Missouri?
Yeah, I mean, a number of other states too are, have done this, but Missouri is sort of the gold standard, right? So they have, and OCFS, to their great credit and to your administration's great credit, have adopted a lot of the steps even in existing facilities as part of the New York model, which is kind of a version of some of the things that they've done in Missouri. So the thinking is that if you really are creating a new facility, though, you have an even more latitude to do it, right? So.
Second question is, you talk about youth parts.
Right.
What do you see? How do you define a youth part in the court system?
So that would be essentially a courtroom that would be presided over by a particular judge whose job it is to handle only the 16, 17-year-old cases or the other juvenile offender cases, the 13, 14, 15-year-olds, so that they would be specially trained in, the brain science and in what adolescents need, the kinds of family services that are needed, the intensive multidimensional therapy, foster care. They would know really, like some of the family court judges do, how best to handle those cases. They would develop that expertise. And so that even if a case stays in criminal court because it's a very serious offense, it would still be handled differently than it is now. And that's a proven concept, and the recommendation is that that OCA do that across the state, and I think they've indicated, Judge Mark was on our commission, they've indicated that that's doable, and it's the right way to go, because you really want, even if it's handled in the criminal court, you want it to be handled well.
Great. Well, very convincing to me. Questions, comments? Don't be shy just because there are 100 people looking at you. You get used to it after a while.
Before people jump in, I just want to add, I would be remiss if I didn't add, I want to thank the members of the commission for their tireless work, and in particular, and I want to thank Sophia Elijah, who's been a terrific co-chair, worked incredibly hard, and we are partners in crime now, no pun intended. And I want to thank in particular Jackie Green, to your left, who I think knows more about juvenile justice than anyone in the state, and worked just incredibly hard to make this a reality. So thank you, Jackie.
Thank you. Thank you all. Sheriff, what do you think? Does it make sense to you?
I think it makes a lot of sense. I've been in law enforcement for 32 years now, and as I sat around the room with these great people on the commission, we all had our own piece in it. And I was surprised that once I made the arrest, it went on to probation or to the family court system, and really I lost track of that. And sit here talking to these people and realizing what steps they would take and how the system needed to be fixed. A lot of our youth at 16 and 17-year-olds, their brains are not developed, so therefore they really don't comprehend what they were doing. And I don't think they comprehended the results that would happen to them in the criminal cases that went up from the court. So I feel that this is going to help our youth of color especially, move ahead in the world, get a second chance, and make them productive members of society. So it was a real honor to serve on this commission, and I've learned so much.
Thank you, Sheriff. Chief?
I'm not too known for my shyness, so I'll speak. First of all, I'd like to thank you for putting this commission together. This has been an incredible opportunity. We in law enforcement and the public as a whole often think that public safety is somehow zero-sum, and that for some reason someone has to suffer if we try to improve things like justice and equality for a group of people, and it somehow has to translate to negative outcomes when it comes to public safety. What this commission will show and what the report will show is, in fact, the opposite is true. We are going to be able to achieve all the things we need to when it comes to justice and equality, all while reducing crime and victimization. And this is an incredible step forward for the state, and I thank you for your leadership on it.
Thank you. Thanks, Chief. County Executive?
Governor, thank you for your leadership on this and for bringing this forward, because like everyone has said, this is not something that this has been lingering, and it's something that needed to be discussed and vetted out, and I believe that the commission has done a great job. I'd like to really just on behalf of the commission to thank Jeremy and Sophia. I mean, they have worked tirelessly to lead us to this point, and I want to thank them for their leadership in this. As a county that knows what diversion does, it's most important in dealing with our youth, but it's also a point of looking at this age group which has no parental involvement when they go to court, which is really tantamount to really trying to get to the heart of what has caused them to lead this. As the sheriff had said, at times they don't know what they're getting involved in. And so these reforms really take us to the level that New York State should be at and put us at the forefront of these programs that will lead to reduced crime rates and better success from our young people. So thank you.
Great. Thank you. Thank you, County Executive.
I would like to echo those comments. I've been doing this for 26 years in the same city that I grew up in, and working primarily in probation and primarily juvenile justice. And the most rewarding part is working with youth and the community on what you can do to help that youth succeed and keep the family together. That was the work that's always rewarded me the most. The most disappointing thing for me would be when a youth would turn 16 or 17, they wouldn't have access to any of those. And the mission is get the conviction, and they would be processed in a system that just wasn't tailored to the youth that age. And this gives communities an opportunity to really diagnose what happened, you know, with public safety in mind. What can you do to wrap some services around that to make that youth and family succeed? So I really commend you on doing this. It's been a long time coming, and I appreciate that. Thanks.
Anyone else?
Yeah, I'd love to take this opportunity to just say also thank you for including me in this work. It was a lot of work, but I think that all of us coming from our different perspectives really came up with something that we agreed on in a way that Jeremy and Sophia mentioned. To come to consensus was an incredibly exciting thing, and the commission looked far and wide. We examined systems all over the country, and we really pulled the best of from each wonderful thing that we saw, and you know, coming from the state of Connecticut and working through raising the age there and seeing the progress that has been made, it's an incredibly exciting prospect that New York could move forward on what really will be you know, the leading juvenile justice system in the nation if this type of reform is implemented. So it's very exciting, and I feel privileged from being a part of this process, so thank you.
Thank you, Emily.
I too just want to echo that as an advocate, being part of this process and being able to sit in a room with colleagues from a really diverse background in law enforcement and government, and some of the district attorneys who aren't here today but were part of the process, it's been really tremendous. And I think that we have come to a really right balance of what's right for children. And largely, unfortunately, Black and brown children are disproportionately affected by these policies, but what's also smart on crime. And it's been a great privilege to be a part of this, so thank you very much.
Right. Thank you.
Governor, can I say one thing too?
Please, please.
So it's also been a privilege for me, also working with Jeremy, my true partner in crime. And as someone who's been a criminal defense lawyer for over 30 years and worked and represented a lot of young people out of Brooklyn, which is one of the counties in this state that has a disproportionate number of those failing schools that you talked about. The work that we've done, if it becomes law, will make a tremendous difference for the people, the People's Republic of Brooklyn, and the entire state of New York. And I'm just so thankful and honored that you've brought us together and that you've made this a priority in your agenda.
Great. Well, thank you all very much. And don't go away, because there's a phase 2 to this, which I failed to mention when I first enlisted you. I accept the recommendations in total. We will now transform it into a legislative package, and then we will go talk to our friends upstairs, Senate and the Assembly, and get that legislation passed. Much of this is counterintuitive, you know, when you first hear it. So I think that you can be invaluable in actually speaking to the legislators who may have questions, and the committees that may be doing hearings on this, to explain how you arrived at these conclusions, what you looked at, what you saw, what the other model programs are. Because it works best if we get the whole package done. And that's going to be our goal, and I very much appreciate your help in that. Did I mention phase 2 when we started phase 1? There's always a phase 2, by the way. We'll put it in legislative language, and then we'll send it upstairs, and then we'll take it from there. When you see this in the state of the state, don't be disappointed. We'll get it down to 7 words, and I don't want you to think that's all there is. It's just the volume of the exercise.